during the law preview class during the summer. But what I want to do is, I'll take you all the way through the deck. I'll focus on things that I think are the most important pieces, and talk about where I see having the privilege and the and the benefit of having relived the horrors of 1L for the last 22 years. I sort of can anticipate, what you guys are feeling, and also, some of the common hurdles that people might misstep over. All right. So what I want to do is quickly give you a quick outline of what your job is as a law student, right? And talking about, first of all, how the exams are going to differ from what you got as an undergrad. And don't worry about taking any notes on these slides. I'll provide the slides to you afterwards. But if you and feel free, please, if you have any questions at all, you can interrupt me, because I do tend to talk pretty fast. So if you want something clarified, or if you just want you have an example to give, or have a question about a current class that you're going through and how it might be tested, please don't hesitate to reach out, all right, or to ask your question, because I'm sure that if you ask it, pretty much everybody else in the on the Zoom will be like, oh wow, that's a great question. Or if they didn't know to ask it, they'll be like, wow, I wish I thought of that. So first I want to just talk about the exam generally, how it differs from what you guys saw before, understanding what a lawyer's job is and understanding what a law student's job is on an exam. Talk about the parts of an examination, talk about what the professor is looking for, what makes your professor's job easier, which is really the entire key here for these, for the exam. You're writing, pretty much everybody walks into the exam knowing the exact same information, and it's really just the students who can quickly dissect a hypothetical fact pattern, reconstruct their answer in a way that makes their job, the professor's job, really a pleasure to go through the exam, who get the top grade. Okay, and then I'm going to walk you through our 5 steps to writing a law school exam. Okay, so let's first talk about what you guys are used to, right? In high school and college, maybe even in maybe some graduate programs that you might have attended. You were really being graded on your knowledge of material, right? And your knowledge of material was being assessed by a professor who said, okay, Ali, you wrote an exam here. You show up for your history class, having learned about European history, right? And your professor, gives you essentially a timeline of European history, dates to remember, important events that happened on those dates, et cetera. And your goal was to regurgitate and repeat. And that's where you gained your points, both in high school and in college. There really wasn't a lot of, of analysis, maybe some, but not a lot. Really, it was more, can you tell me what I told you? Yes. Okay, Ali, you wrote 85% of the material, therefore you get a B. Lewis, you wrote 90% of the material, therefore you get an A-, right? You're being graded against me as the professor who taught you, right? In law school, you're not being asked to regurgitate, right? Your information, the information that you're providing to the professor, your knowledge of the law is basically assumed. Right, your professor isn't questioning whether you have the ability to memorize elements of a certain area of law, intentional torts, right? So what you're going to be tested on is your ability to apply the black letter law. Okay, so rather than you still have to demonstrate that you've learned the black letter law. But where your points are going to be gained is in your analysis of that law, right? And the other big difference between your exams prior to law school is that you're being graded on a curve, right? So it's not about, you're not being graded against what the professor knows. You're being graded against what your classmates on either side of you know, and therefore in order to get the A, You don't have to know it all. I mean, it helps, right? Yeah, you definitely want to walk in with a mastery of the black letter law and your ability to apply it to any situation. But if there are 20 disputes to spot, right, and you only spot 10, you could still get an A if everybody else spots, 9 or less. Okay, so just understand, that's one of the important factors that a lot of students, don't think about when they're taking a law school exam, is that they think that a mastery or their knowledge of the black letter law is going to be enough, and it's not. Where you're going to distinguish yourself is in your argument section, right? The arguments you make for or against the application of a legal rule. All right. So let's quickly talk about what lawyers do. I'm just going to reduce my screen here. There we go. All right. So what lawyers do, and then we're going to talk about why exams are structured the way that they are. All right. So lawyers will, sorry about that. Probably see my Outlook pop up. Oops. All right. So what lawyers do is, a lot of the times they're just advising clients, right? Advising them on future activities that they want to take. They want to, you have two companies that want to merge. They will come to a lawyer and say, these are the steps that we want to take. What are the legal implications of it? All right. A lot of the times it could be, things that happened in the past. I hit somebody with my car. Therefore, what are my rights and obligations as, a potential litigant, and what are the best ways to strategize? Should we settle? Should we sue? Should we, try to avoid litigation? Do I have good defenses? Possibly. So all of those things, understanding what a lawyer does is mostly advising clients, right? And what your law school exam is trying to do is trying to replicate what happens in practice. All right. So rarely will a client walk into your office and say, I have a breach of contract case, right? Or I have an adverse possession claim against my neighbor, right? Or my neighbor is encroaching on my property. I think they might be trying to adversely possess it, right? Or I think I have a really good negligence case. Never do they do that, right? Most of the time, what clients will do is they will come into the lawyer's office, even if they're sophisticated business people or simple mom and pops that find themselves in hot water or legal hot water, or possibly legal hot water. They will come in and just tell a story, right? And the story will, they will, tell the lawyer, hey, this is what happened. And a lot of the times the story has nothing to do with the law, right? A lot of the times, a little old lady will come into your office, drop her purse on her knees and start talking about, how she met her husband, right? In 1938 at the USO, right? And how they have 18 grandchildren, right? And you're sitting there, trying to be respectful, listening to this entire story, and they're like, well, can I help you with something? And like, oh yeah, my husband was hit by a truck last night. So that's where your job, right, as a lawyer is going to be identifying disputes that arise because of relationships between people, right? So whether it's a formal legal relationship like a co-tenancy, right, or a marriage, or simply you have parties that are adverse to one another, a landowner and a person who slips and falls on their property, right? The lawyer's also going to identify legal issues that arise from those relationships, all right, and then apply rules that they know, right, to settle those disputes, right, and determine what a client's rights or obligations are under the law. Okay, so is that clear? Does everybody understand, sort of what a lawyer does? Because it'll make your job a little bit easier when you're taking a law school exam to understand what your professor is looking for. All right, they're looking for students to take a hypothetical fact pattern, take a story, right, and through that story, identify parties that possibly are in dispute. All right. identify the relationships that will, that will govern that dispute and the legal rules that will govern that dispute, and then decide whether those legal rules apply or not. All right. So as a law student, sorry, let's go here. Your job is pretty simple, right? You're identifying legally significant facts, right? And for, for most, as I said during the law preview class, anytime you hear elements, like the elements of the law are X, Y, and Z, right? Or 1, 2, 3, always think facts, right? An element is simply a fact that is going to satisfy a prima facie case for a cause of action under the law. All right. So when you're reading a hypothetical fact pattern, what sort of jumps out at you should be these legally significant facts, whether they're all present or not. We'll talk about that later. All right. But you want to identify, oh, okay, I'm in my torts class. Let me identify whether there was a duty between these two parties, right? Whether there was a breach of that duty, right? These are simply facts that you're trying to identify. Whether somebody suffered a harm because of that duty, okay, or the breach of the duty, I should say, okay. You want to identify the legal disputes, the issues raised by those facts, right? Are all the facts present, right? Can some facts be misinterpreted or interpreted in more than one way, right? Are they ambiguous? Do you have to satisfy a legal rule to establish a particular fact? All right. And then what you're going to do is you're going to identify the rules that the parties are going to raise, and anticipate the arguments that both parties will make, either in support of or against the application of that legal rule. And then ultimately, at the very end, make a prediction. Okay. And in terms of that prediction, just say who do you think has the better facts, right? Who has the better legal arguments in support of or against the application of that rule. It's really, really that simple. Where it gets confusing is, you're asked to do a lot of the heavy lifting, including writing your own questions on a law school exam. But we're gonna talk about how to do that in a little bit. So before I go any further, any questions up until this point? Anybody surprised by this? Anybody listening? All right. Okay, so let's talk quickly about the parts of an examination. One of the reasons why I encourage you during the orientation to go and try to track down your professor's old examinations. One of in addition to having a great study tool, I promise you this, that if you're able to get your professor's old exam, the instructions that appear on the cover sheet probably haven't changed in the 20 or 30 years that professor has been teaching that class. Professors are, just like everybody else, they are either, lazy, they've got other things in their life going on, they've got kids, they've got puppies. So once they've, established a pattern that they like for an instruction on an exam, they pretty much stick to that, all right? So what I want you to do, in addition to understanding how they ask their questions, what I want you to do is get used to the type of exam instructions that you'll see. All right. So on the front of the exam, you'll see, the time governing the exam. You want to know exactly how much time you have, and we'll talk about, that's the very first step in taking a law school exam, is making sure that you manage your time both on a macro and a micro level. All right. The instructions for the students, like what materials you can reference, right? How they want their answers, whether it's a word limitation, whether it's a spacing, like they want to have double spacing between each line. What you want to do is you want to give your professor exactly what she asked for. All right. You do not want to try to, oh, I think she means this. No. All right. If your professor says, look, you are limited to 5 blue books, understand you are limited to 5 blue books. All right. She's doing that for a reason, because she has her own process. And she has her own life, right? By the time that you're done with your exams in December, and your professor is sitting down to grade your exams, guess what? It's winter break, right? And your professor's got family obligations and holiday parties to go to and New Year's to celebrate. And she turns to your examination and you're not following the instructions, it's gonna mess with her process. So you really want to understand the procedural rules of what your professor is looking for on those exams, all right? Understand the different types of exams that your professors tend to ask. Now, obviously, this cannot be, this isn't automatic, but traditionally, if a professor, asks 2 essay style questions and 20 multiple choice or short answer, they traditionally continue to follow that pattern, all right? So what we want you to do is just sort of get familiar with the types of questions that they're asking. Now, one of the things that we're, and Diane, I didn't mention this, because I just got invited to it yesterday. BARBRI is putting on an event for all the law preview students who took law preview over the summer, and it's a 1-hour exam lecture where we're going to focus mostly on multiple choice questions. And during the law preview class during the summer, we focus almost exclusively on essay style questions. But BARBRI is, the expert in standardized multiple choice MBE style questions, and we're going to focus on how to answer those tomorrow night. So for those of you guys, I believe it's I think it's 6 p.m. Tomorrow night, but you probably got an email from BARBRI already letting you know about that. And if you haven't, reach out to me and I'll send you an invite. But from a multiple choice style question, recognize that it's structured a lot the same way. There'll be a call to question, what question you're being asked regarding a hypothetical fact pattern, and then you'll be given a series of answers, right? 4 or 5 answers. All of them might seem really good, all right? You're not looking for a good answer. You're looking for the best answer, okay? So that's one thing I want you to focus on, all right? But we'll talk a little bit more about multiple choice questions, either later when you have questions about this, or tomorrow, like I said, if you wanted to attend the class with BARBRI. All right. The other thing is the essay, law school essay style questions, all right? And this is the traditional issue spotter where you have a fact pattern. Your professor writes this, convoluted hypothetical fact pattern where people are doing, natural, supernatural, crazy, horrible things to one another. And then your professor will, in the call to question, give you some kind of a, call to question that says simply, address the rights and liabilities of all the actors, right? Lucky you, all right? At that point, you're writing your own question that you have to answer. And I'll talk about that in step 3 when we talk about framing a dispute, okay? So there's, there's that type of question as well. Other things that I want you to know, be familiar with prior to walking into your exam is timing, all right? Like I said before, one of the biggest parts of conquering your first year exams is simply finishing it. The majority of your classmates won't finish this exam, all right? You have to be in a position that you're going to finish it. So we'll talk about micro time management and macro time management in a moment. But every section of your exam will have a time limitation or points allotment to it. It'll also have a hypothetical fact pattern, and it'll also have a interrogatory or call of the question. All right, we'll talk about that in a moment. All right, is this sounding familiar to you guys? You guys are remembering? Yeah? Yes? Do I need to play Dia Lupa again just to pump you guys up? Okay. So what are your professors looking for? All right, I guess knowledge of the rules, but like not really. I mean, they're assuming that you have the knowledge of the rules, right? So like you have to have that to show up for the exam. A real mastery of the black letter law is it's assumed. The ability to spot legal disputes, that's a little bit more sophisticated. That gets into analysis. So your ability to identify which legal rules apply without them asking, show me, a battery, or tell me what a battery is. They're going to describe a hypothetical fact pattern in which a battery arises. Okay, so your ability to analyze a hypothetical fact pattern and find the legally significant facts, those elements that rise up and create disputes between parties. Okay, and then where they're going to grade you is your analytical skills. Right? Does this rule apply? Does this rule solve a problem for, solve the dispute between these parties? Right? And for that, you're going to use factual analysis, right? Legal analysis, or policy analysis, right? These are arguments, okay? Your professor's also looking for organization, all right? And I'm going to talk about the best way to organize your answers, and concision, all right? They're not looking for you to be long-winded here. There's not a lot of throat clearing on a law school exam. Your typical essay in college was, let me give you 6 pages of bullshit, and then at the end, throw in all the other stuff that I think I know that you want, all right? Your professor's not looking for that, all right? Your professor is looking for you to hit and move in an organized fashion that, identifies the legal dispute, states the operative rule that's going to, that the parties will use to assert either, in support of or against the legal rule, and then those arguments, right, that we just talked about, and then finally just come up with a conclusion. All right, I'll talk about that in a moment. All right, what aren't they looking for? They're not looking for legal conclusions. Okay, you can't walk in there and say, and fully assume that, Diana is liable for negligence because X, Y, and Z. They want you to prove that Diana is liable for negligence, all right? They're not looking for grammar and spelling, all right? So this is another thing that students get hung up on, is trying to write the perfect essay. The perfect essay doesn't exist on a law school exam. If you look at some of the hypothetical fact patterns that we gave during law preview, or if you go and take one of your practice tests, during the reading period that your professor gave, in prior years, you'll quickly realize that, some of these questions can't be answered in an hour. All right. Some of these questions can't be answered in 2 weeks. All right. There's too much going on. So, your ability to write the perfect sentence or have the perfect spelling, is not the end goal here. Right? They understand that you're under time pressure. All right. So, obviously if there's spell check, by all means, spell check it. Right. I'm not asking you to type with your feet. But what I'm saying is, like, don't go crazy trying to, to write the perfect sentence or have an introductory paragraph, have a thesis statement, have, a well-formed conclusion. This is not what this is different kind of writing. It's more like bullet point writing. All right. Your professors aren't looking for jokes, flattery or compliments. Like, oh, let me just tell you, professor, your class was the greatest. All right. They think they're the greatest anyway. All right. Trust me. All right. Having dealt with these people for the last 20 years, you can't give them any compliments that their mind doesn't already exist. All right. So what are the things that you want to do when you're writing your exam? Again, remember that your professors are people. Okay. And, regardless of whatever you do in life, all right, recognize that when you make people's jobs easier, they like you. All right. So, follow their instructions. All right. If you're instructed, if you're given the option of typing your exam on a computer or handwriting it, I strongly consider that you type an exam. All right. I have a former professor who's at Columbia now. He's a statistics, guy. And he taught contracts for law preview for a number of years. And he went back and did a statistical analysis of, 10 years of his own grading. And found that he grades people who type their exams easier than people who wrote their exams. all right? And, again, think about it from the standpoint of these people are just human beings that want to enjoy their winter break too. And, one of the things that they have going against them is, your exams are done December 15th. The registrar wants all grades or all grades for every student in by December 28th, right? Not a lot of time there, to get those exams, especially during that time of year, right? So you want to make your professor's job as easy as possible, all right? So if you have the option, type. Don't write your exam. If you can't type, if you type slower than you write, okay, then write, but make sure you print. Do not write in script, okay? Because another thing that you don't know, or maybe you do, is that your professors will struggle to read every word of your exam. Because the last thing that your professor wants to do is make a mistake on a 1L exam. And the reason is, very selfish on their part. They don't want to look like an idiot. So what happens is, and this, they will struggle through your chicken scratch to make sure that you're getting the grade that you deserve. Because otherwise, if you go in and try to contest your grade, right, and show, hey, professor, look, you didn't give me credit for this, but it was actually here, right? If for some reason they have to change your grade, do you know what they have to do? They have to assemble a panel of all the first year professors, not only in their courses, right, but in other courses. So they're teaching crim law. That professor, at Brooklyn is teaching crim law. If she messes up and, on Diana's grade, and Diana successfully contests it, she has to go before all the professors and says, look, I have to change this student's grade, right? Presumably she's arguing it to be higher, right? And the reason why they have to go before all the other professors is because by raising Diana's grade, you're going to knock somebody else down in the ranking system, all right? So mathematically, if it's a mathematical error, there's no problem, right? It's not a big deal because, we all know that everyone went to law school because we all suck at math, right? So like mathematically, professors get a break, like, oh, look, you added up my points wrong, all right? And, usually their colleagues are like, oh yeah, well, that would happen. I can see that happening too, on my part. So I'm not gonna give you too much slack. But if they, from a substantive standpoint, if they have to argue, like if they have to change your grade, it is a big, like, oh, wow, I really screwed up here, all right? Nobody wants to do that, right? So they will struggle through your exam. They may hate you for it as well, all right? So try to make your professor's job as easy as possible. I tell students all the time, like when you're writing your law school exam, imagine your professor, she's, it's December 26th, all right? Wrapping paper all over the house, right? Kids going crazy. But now it's 2 o'clock in the morning. She finally got some free time. There's a pot of coffee next to her and there's a stack of blue books this high and she's pulling yours, right? Make sure that this is going to be an enjoyable experience for her, right? Make her job easy. Use large readable font if you're typing it or if you're going to be writing it as well, right? Double space your lines, right? This is good for a couple of reasons. One, it's easier on the eyes. All right. And also, if you need to go back and insert something, you can go back and insert something and make a quick correction and have a little bit of space to do so. All right. If you're writing, because I'm assuming that you all have developed some kind of a shorthand for note taking. So K is contract, or the pi sign is plaintiff. Don't assume that your professor knows what your shorthand is. Right? For every one of your exams, put at the very top, here's the key that I use. On the other hand, OTOH, right? Foreseeable for cable, right? A D for defendant, all right? Whatever it is, let them know this is what I'm doing. So either you can put a key at the top, or as you go through the exam, you can put a defined term. So they understand what your shorthand is, okay? use very straightforward language, breach of contract, rather than, and if you're going to use breach of contract, even though it sounds repetitive, who cares, right? This is not formal writing, right? Make sure that you're using the same exact, terminology throughout the entire exam, okay? All right, so any questions on the introduction? I'm gonna pause here for a second.
Don, we had a question in the chat.
Oh, sorry, I didn't even see the chat.
Oh, no, I can point them out to you when they come in.
Thanks, I appreciate that, yep.
Are there any cons to using a shorthand even with a key?
No, I don't think so. I mean, unless you have like some terms that are, offensive, I couldn't imagine, what shorthand, if you're providing the professor with, this is what this, shorthand means, I think the professor appreciates it. And, will continue to read your exam the same way. The only thing I would say is, as you go between sections, right, of an essay exam, if there's 2 essays, you might want to provide 2 keys. Because another thing that you don't know about professors is they don't typically grade you throughout your entire exam. They don't sit down and start, on page 1 and end on page 60 of your blue book, whatever the exam is. They always, traditionally what they will do is they will read and grade essay number 1 for everybody. All right. They will read and grade essay number 2 for everybody. Right. And then so forth. So by the time they come around to essay number 2 for you, they most likely have forgotten your key from essay number 1. All right. Any other questions? Let's see.
Yes, so I actually have a follow-up question about what you just mentioned. Yep. I'm kind of wondering, like, how do they determine, like, what's the highest score if they go through, like, do they go back and grade them again after they've seen all of everyone's test, or how does that work?
Yep. So usually what they have is a key, and they say that, on essay number 1, there are 25 potential disputes between the various parties. And you'll get a number as to how many disputes you spotted, and then also within those disputes, how you solved that problem, right? How you addressed, did you, a letter grade of some sort regarding your application of the various rules, okay? And then really at the end, they're just adding up numbers, right? So they might have a, Diana might get, 10 disputes with, a grade of, 9 out of 10 for her analysis, right? Of those 10 disputes, where somebody else might spot 15 disputes, but get a 4 out of 10 on their analysis, right? So they're grading it on 2 different levels. One is how well you're able to identify and spot disputes. And then 2, most importantly, I should say, is how well you're able to argue the application of the various rules that you're applying to resolve those disputes, if that's helpful. Does that make sense?
Yeah, that is. Thank you.
Yep. Okay. Anything else before we start in here with time management? And I get into a little math here, so brace yourself. All right. Okay. So we have 2 types of time management on your exams. All right. There's macro, the time management that's going to manage your entire exam and make sure that you finish every part of the exam. All right. One other thing to think about is, where students I see typically fall apart is they spend a lot more time on earlier parts of the exam, right? And then are rushed through the later parts, right? So they're essentially stealing time from themselves, right? From later parts of the exam and applying that time to the earlier part of the exam. Well, guess what? If your professor, like most professors, is grading essay number 1, essay number 2, multiple choice, section number 3, right? If you don't make it all the way through the multiple choice sections, or you don't finish the essay number 2 because you've given too much time to essay number 1, your professor's not going to know that, right? They might, like, some students walk in thinking like, oh, if I wow them on the first part of the exam, they'll cut me some slack on the latter parts of the exam because they know it's time, it's time sensitive. Well, they're not going to remember that you wowed them on, the first part of the exam when they're grading part 3, because they graded that maybe 2 or 3 or 4 days ago. Okay. So what you want to do is make sure that you're putting yourself in a position that you can finish this exam. And another thing that I think students don't understand is that, yeah, if you have a 3-hour exam, all right, and you have 3 different parts, 1 hour, 1 hour, and 1 hour, all right, and you spend 2 hours on part 1, all right, you've basically changed the exam, right? Your professor it's as if you changed the question being asked. Your professor will say, oh, wow, this person did really well, and did a really good thorough analysis of section 1, not knowing that you spent 2 hours on it, right? But when you get to section 2 and 3 and you've only spent a half hour, let's say, on either one of those sections, they're just going to assume that you just didn't know it, right? So the last thing you want to do is steal time from other parts of your exam. And we'll talk about how to make sure that you don't do that, okay? So the very first thing that you want to do is understand how much time you have totally, and how you manage that time. Now, one of the things that you might see, and this is where math comes into play, and I apologize, but some professors are very fancy, all right? And instead of telling you how much time they want you to spend on an exam, they say, use your best judgment. I'm going to tell you how many points these questions are worth, all right? If that happens to you, and this happens a lot, all right? If your professor says, oh, I'm not going to tell you how much time to spend on this, you decide, I'm just going to tell you how many points each of these sections is worth. What you need to do is convert those points into time, okay? So if you're given 3 hours, 180 minutes, I'm now looking at this slide because I can't do this math in my head, all right? And it's got 3 different sections worth 100 points, all right? What you have to do is divide 180 by 100, right? So you get 1.8 minutes per point. And then you just go back and say, okay, for the 10-point multiple choice section, I'm going to have 18 minutes, right? I'm taking 1.8 times 10, right? I'm not going to give myself any more or any less time than 18 minutes. At the end of 18 minutes, I am moving on to the 40-point short answer section, which I'm going to spend 72 minutes answering. All right. And then, for the final 50-point essay question, I'm going to spend 90, half of my time on that, right? Because your professor is telling you, hey, this is worth half of your grade. Where you are, and I can't emphasize this enough, all right? The time management piece of this exam taking, lecture is the most important part of this, right? More than half of your classmates will not finish this exam. All right. I dare say there will be, 15% of your classmates who won't get to the 3rd section. All right. This is, as I started out this, for those of you guys who arrived a little bit late, today, if you don't know it, is the day that they're offering the SAT. And my son is sitting in a classroom right now, probably, pulling his hair out, trying to get to the exam. And as I told him this morning, I was like, look, all you want to do as a 16-year-old boy, right, on the SAT is finish this test, right? We can worry about grades later on, how to improve, but all you want to do is finish. Simply by finishing, you're going to put yourself in a different tier of percentile people who don't finish. All right. The same thing holds true for a law school exam. All right. You have to finish the exam. You have to address every part of the exam. And simply by doing that, you're going to take yourself out of you're going to self-select yourself out of a group of people who will not be finishing. Okay. So micro time management. So that's the macro. Sort of, you get a good picture of how much time am I going to spend on each section of the exam. And what I want you to do is, as you sit down in the exam, I want you to flip through and see exactly how much time you're spending on each section. And then for the micro section, right? For each section, how you're going to spend that time, right? On your on your essay questions, I want you to spend about a quarter of the time reading and analyzing the question. Don't race to start writing, all right? Sit, relax, all right? Read the question, identify the legally significant facts that are arising out of that, mark up the answer, right? We're going to talk about the flip-flop tree in a second, you know, how to outline your answer, right? But read, analyze, outline, and then spend three-fourths of your time writing the answer. And I'll talk to you about the format for that. Okay. But to keep you on track, you have to write down, hey, this is when I began this question. This is when I need to start writing. And then this is where I'm going to end. Lewis, you have a question. Thank you for raising your hand. I appreciate that.
Hey, no problem. I just had a question about like when it's point-based and we have to convert the points to minutes. Is that going to take away from like our time of actually doing the exam?
It is, but guess what? You're going to practice that and it's going to be very fast. You're going to spend a minute doing it.
Oh, okay.
All right. It's not, this is, again, I'm not asking you to like do long division, carry the 4, have an exponent. This is like, trust me, you know, even I could figure that out in terms of the math. But, you know, by taking that 1 minute, and again, also don't be surprised if you've already seen your professor's exams that they're structured the exact same way, right? So you'll hopefully be conditioned by seeing some past exams as to how your professor is going to, you know, budget the time for you. But you know, that one step, I promise you, half of the class won't do, right? Half of the class will not really sit down and say, okay, it's a 3-hour exam. You know, 40 minutes is devoted to, or 40 points is being devoted to the you know, to the short answer. I have to spend 72 minutes doing that. They're just not going to do it. All right. So you're really, just by doing that simple math, that's going to take you about a minute or possibly 2. If you really are as bad as me and you need like an abacus and count with your fingers and your toes, then you know, that right there is just going to take you a couple minutes, and then it puts you in a really good position to finish the exam. All right, answer your question. Cool. Again, micro time management on the essays. A quarter of the time is going to be spent reading, analyzing, highlighting, marking up, outlining before you start the 3/4 of the time writing your exam. Okay. So if 60 minutes, I'm spending 15 minutes. All right. Reading the question, getting my thoughts together. How am I going, you know, what's the best way to analyze this question? It's a 3-page hypothetical fact pattern, right? And don't be surprised if you see that. Should I break it down by type of dispute? Should I break it down by party, right? If oh, wow, here's a breach of contract claim. First, I have to establish whether there is a contract. Okay. If I decide that there's no contract, am I distinguishing or extinguishing other disputes that I should be addressing? All right. Thinking through that critical, you know, that organizational structure is going to help you out. Relax. All right. You're going to hear people, you know, open up the exam and start typing. You're going to hear clicking and clicking and clicking if you're taking this in the classroom. Don't get freaked out. Put in your earplugs. All right. And just go, I'm going to read this exam. I'm going to analyze it. I will have plenty of time to write. Now, you know, you eventually will have to start writing, right? But your answer is going to be a lot better organized and a lot more thoughtful if you take that time and just relax, read the answer, read the question or the hypothetical fact pattern, formulate the question, and then analyze it. Okay. For micro time management for you know, multiple choice or short answer, it's pretty simple. All you're basically going to do is, once you've identified that I have 30 minutes for 15 questions, right? You're going to divide 30 by 15, and you're not going to spend any more than two minutes per question, right? If you find yourself struggling, pick an answer and move on. All right. This is about hitting and moving. All right. Because the last thing you want to do is get to the end of that section and have 5 or 10 questions that you can't answer or you haven't answered because you spent way too much time struggling or wrestling with the fact patterns and the hypotheticals at the beginning of that section. All right, make sense? Good. Yeah. All right. As I stated before, thanks, Lewis. I appreciate the thumbs up. I'm glad that somebody's listening. As I stated before, one part of every exam question is something called the interrogatory or the call of the question. All right. Usually these take place at the end. If that is the case, all right, read the call of the question before you read the hypothetical fact pattern. All right. Read what role you're being assigned by your professor. All right. Are you a prosecutor? Are you a defense attorney? Are you a lawyer who's counseling? Are you a judge? All right. Identify what role you're being asked to play and understand what question they're asking you to analyze based on these facts. It's going to make your job so much easier, right? And as you're reading the fact pattern, you're going to walk through it with a guidance of, oh, okay, again, my role is X. Now, understand that if you're the prosecuting attorney, it's not about throwing the criminal behind bars, right? It's about, okay, it's identifying what crimes we can try to prosecute them for, but also pretending that I'm a defense attorney as well, anticipate what arguments the defense attorney is going to raise against the application of the rules for those crimes. Okay, so always read the interrogatory first. This is simple, but again, a lot of students will freak out during the exam and quickly turn to the hypothetical fact pattern and start reading it and not understanding what they're reading it for. All right, and again, I'm trying to make you these super efficient law students who not only have the time to write an exam answer, but have a thoughtful process of reading an exam hypothetical. All right, so after you've managed your time, flip right to the interrogatory or the call of the question and start reading that, and then go in and read the hypothetical fact pattern. Right. So before I step on to to step 3, any questions regarding time management or reading the call of the questions? Nothing? Okay.
Oh, I guess I do have a question, but I'm not necessarily sure. It's not like for time, like for exams that you have 24 hours to do. Is there like a particular strategy for those?
My strategy would be that you organize the entire first year class to have that professor removed as a professor. All right. That is mean, right? That's cruel and unusual punishment, right? Because look, Diana and I are competing against each other for our grade, right? And it's just the meanest thing ever, right? A 24-hour take-home exam, I have to say, like, how long am I going to spend on this? And it's not really dictated by how long I want to spend on this. It's more dictated by how long do I think Diana is going to spend on this exam, right? Because one thing you don't want to be, in law school is outworked, right? So if Diana, I have to assume that Diana is going to spend 23 hours and 45 minutes on that exam, and therefore I have to do the same. All right. So if you have a 24-hour take-home exam, first of all, I apologize. That's mean. All right. That's just absolute, that's just horrible. Do you know whether there's got to be a page limit or a word limit on the essay or on the response? Do you know?
No, I don't know those specifics. I just know I saw in the syllabus that it's like a take-home 24-hour exam.
Yikes. I mean, even like an 8-hour take-home exam is fine, right? Because you can do that, but like a 24-hour take-home exam is just cruel. Yeah, I mean, all I would say is you're going to spend a lot of time doing that. All right. So I would guess, as you're studying, get plenty of sleep. And I mean, obviously you're not going to work 24 hours, right? But, you're going to put in a fair amount of time. You're going to put in 15, 16 hours on an exam, and, because frankly, you just don't know what anybody else in the class is going to be doing, and then even if you guys were all to agree to say, like, we're only going to do 12, like, I don't trust Diana. She seems nice, but, like, she's a gunner. All right. And that's how you get to a Melody, right? Is you outwork people. All right. So really, I mean, all of these tips are good regardless of what style or type of exam that you're going to be taking. But from a standpoint of a take-home exam structured as that, I mean, it's just, I don't know. It's really, that is just cruel and unusual punishment. So I apologize for your professor, who maybe he or she would never apologize for themselves.
Okay. Well, thank you.
Diana, did you ever have a 24-hour take-home exam?
Not 24 hours. All of our exams were take-home exams. I mean, this is quite a while back, but they were like, I feel like 8, maybe 10. Like, it was the full day.
Yeah.
And I definitely had to structure it like, this is a day, like from this hour to this hour, do this. But I structured breaks. Like, for me, I need breaks. I need to, like, turn off, have a 15-minute dance party, like, just completely separate myself so then I could come back and then focus. And there were, like, page limit and word limits. So you kind of had to really streamline everything down, but they were brutal. And I took them home. I know some people did them at the library. For me, like, I just had to get out of that space. So I would actually, like, drive down to the law school, probably waste almost an hour just picking up the exam and taking it back.
Yeah, I would say the exact same thing. I would, if you're going to do any, regardless of the length, I wouldn't do it in the library. The last thing you want is, the mayhem and the stress of people next to you typing, and, you just sowing the seeds of doubt in your own mind as to, like, oh, what do you think Diana's doing in there? She's in the computer lab and she's, I think that's happening. Like, typing away. We have a question from, is it, I can't see your name, Jalea?
Capricia?
No. Oh, Capricia, sorry. Yep.
Okay, I have a question. So, my contracts professor, we have multiple choice, 2 short answers and a long, like a longer response. And so I guess, like, because I took a midterm, where my question is that we have, I don't know. So, like, when we have the short answers, the 2 short answers, we're giving one time, but like, one question might be call for a little bit more effort than the other. Like, what is your suggestions on time management for that, like, for that short answer portion?
So, like, so I understand, is it short answer, like you're answering it in, a sentence or a paragraph?
Like a paragraph or 2.
Okay. And there's 2 short answer questions in that section?
Yes.
Yeah, I mean, you're splitting the time evenly.
Half and half.
Yeah, I mean, I guess you just sort of have to, because otherwise you don't know what the second question is going to look like and require of yourself. And if you have more time, then obviously you can go back and add to the first question if you get through the second question quickly. But I think that from a time management standpoint, I think that if you've got 30 minutes, you're doing 15 minutes on each of those short answer questions. What do you think, Diana?
That sounds good to me. That makes sense.
Yeah. And like I said, if you're finishing, oh wow, like the second question only took 5 minutes. First of all, you might want to check yourself, right? Because maybe that's not the way it was supposed to be structured. But if you truly answered the question in 5 minutes, then go back and spend an extra 10 minutes on the first question. Right?
Okay.
Make sense?
Thank you.
How'd the midterm go?
I made the curve, so I'm in a good position. And my professor has office hours to discuss our midterm. So I'm looking forward to that to see how I can improve.
Good. Have you, when is that meeting?
My meeting's on next week, actually.
Okay, good.
And then we take finals in December, so.
Right. And I think I mentioned it during law preview, but like when you're actually done with your first semester exams, you know, and your grades are released in January or February, you should definitely go into every one of your professors, whatever grade you get. If you get the A+, you're still going in there to, you know, find out A, what they liked about it, and B, you know, so the professor can put a face with your anonymous number. Sometimes they don't know who you are, right? So, you know, if you didn't do as well, find out how you could have done better. And, you know, that's always a good exercise, and, you know, similar to what you're doing on the midterm. But on the final exam, especially if you do well, you want your professor to be like, oh, Diana, that was you. Oh, okay. And then, you know, at that same time, you can sort of like, hey, are you looking for a research assistant or what have you? Start networking with your professors to sort of ask them for references or, you know, jobs or what have you. All right, any other questions before we move on to framing disputes? So a really frustrating part of, you know, law school exams for a lot of students is that they're given a hypothetical fact pattern. There's an interrogatory, right, that says discuss the rights and liabilities of all the actors, but there's no questions, right? Your essay, you're being asked to, you know, answer a hypothetical fact pattern, but you don't have any questions. So one of the things that I have students do is identify and frame disputes, create your own question. All right. Because, you know, you trying to answer a hypothetical fact pattern as a whole is a recipe for disaster. You know, what you want to do is break down each of the, you know, identify and frame disputes between parties and then answer those discrete questions, right? That's what your professor is looking for, right? They're not looking for, you know, whether this person can go to, you know, prison, or whether they're, you know, liable in tort or for breach of contract. They want you to identify and frame particular disputes and then answer them. And the beauty of that is you're getting, you know, you're asked to write the question that you're going to be answering. All right. So to do that, understand what parties could be a possible parties to a dispute. All right. So you have natural persons, right? People, you know, children. You have artificial entities, right? You'll have corporations. You might have government or state agencies. You might have partnerships. Regardless of, you know, who the parties are, understanding that, you know, you could have a person versus a corporation, right? Or a state government versus a woman. So understanding who the parties are in the dispute, all right? And then understanding what the, you know, identifying the dispute by the harm that is that's caused, right? So you identify that one person was harmed by, you know, what you're going to, you know, argue is a breach of contract, or a, you know, negligence by another party or a corporation. You're going to structure the question in a manner that, you know, identifies the party, right? Identifies the harm producing act or omission, right? And oftentimes it's going to be something that they didn't do, right? So you have to look for that as well, all right? Identify the legal theory that the party is going to use, you know, one of the parties will use to, or try to assert to redress the harm, and then structure that as a question. All right, so I think you probably remember the hypothetical fact pattern that we used in law preview, and it's in your materials if you don't. But it's the young child who goes into the general hospital, and, you know, she's choking on something, a doll that she received as, you know, as part of a Happy Meal at a fast food chain. And, you know, one of the questions happens to be like whether, you know, the doctor performed the Heimlich maneuver in a way that was, I don't know, can you see my screen here? I can't see it. You know, improperly, right? He broke her ribs while performing the Heimlich maneuver, right? So you know that you know, you've got the harm, you know, the broken ribs, you've got the victim, you know, or the plaintiff, presumed plaintiff would be Cindy, the little girl. Dr. Green is the inflicting party, the person who was performing the Heimlich maneuver. And then, you know from your understanding of tort law that the theory, the legal theory which you would try to collect under would be medical malpractice. Well, what you would do is before answering the question, oops, let's see, what am I doing here? Sorry. You would frame the dispute, right? So you're going to identify the two parties, right? Cindy and Dr. Green. You're going to talk about the harm-producing act or omission, in this case, the Heimlich maneuver, and then the legal theory that Cindy, the plaintiff in the case, will be using to assert the. Hold on one second. Will be using to assert the the claim. So is it Hadaya? Hadaya, sorry.
You're fine. So I just wanted to clarify that on the chart that you had, each of the horizontal lines represent like their own legal dispute that would have their own like separate like IRAC type answer to it.
Yep. Yeah, absolutely. And you can use IRAC as the nomenclature, but I'm going to talk to you about DRAC, which I think is what your professors really want. All right. IRAC I get a little nervous with because I feel it's it pigeonholes you into a certain train of thought. And DRAC I think is a little bit more is a little bit broader, and it forces students into the correct analysis. Okay, but yes, every one of those lines would be a separate dispute that would be argued, right? So dispute number one, whether Cindy can collect against Dr. Green for his performance of the Heimlich maneuver, which resulted in her broken ribs, using a theory of malpractice, right? That's how you would structure the question. I mean, there's a million ways you could structure it. Whether Cindy can, section, the second one, right? Whether Cindy can collect against, recover against Dr. Green using a theory of medical malpractice when he used a medical device that broke off in her mouth and resulted in broken teeth, right? Do you see how I'm tailoring this question, with the parties, with the legal dispute, and then also with the harm that was caused by it? Does that make sense?
Yes. So I guess a follow-up question, I'm assuming like this type of chart is something that you would want to have in an outline.
It could, yeah. And we'll talk about how, I mean, my guess is, you don't want to spend too much time charting this stuff, right? If you have an 8-hour take-home exam, sure, make a chart, right? But if you're on a 3-hour or 4-hour in-class exam, you're not making charts like this, right? This is you're dissecting the hypothetical fact pattern, and you're circling facts, and you're writing out med mal, C versus G, Cindy versus Green, right? Make sense? Because there will be a part where I want you to sort of actually formally make a chart, which is called the flip-flop tree. But that comes a little bit later. This is really just very broad, very high level, analyzing which legal questions you're going to address. Make sense? Okay. Any other questions? No? All right. Good question, Hadea. All right. So again, here's the hypo with respect to Dr. Green and Cindy, and using the all of those parts of the dispute or frame. We're going to frame it as whether Cindy, and I love the fact that the person here, me, who identifies Cindy as C, right, and Dr. Green as G, because you're now giving the professor a key that you're going to use as shorthand for those parties, can recover against Dr. Green for med malpractice when he broke her ribs while performing the Heimlich maneuver. Understand, you're making no conclusion as to, in your framing, as to whether or not he's liable. All you're saying are the facts that you're given, right? He performed the Heimlich maneuver. He ended up breaking her ribs. Okay. A bad framing of that dispute would be something that's way overgeneralized, right? Whether Cindy can recover against Dr. Green for medical malpractice, right? or yeah, those are two very, very broad framings of the dispute, right? They're not tailored to what you want to do, and it makes it really tough for you to answer that question. Another one would be one that has a legal conclusion in it, right? Whether Cindy can recover against Dr. Green for his negligence because he broke her ribs, while performing. Well, no, that's what you're going to show whether he was negligent, and could be liable in a medical malpractice. The broken ribs might just happen to have happened as a natural course of doing the Heimlich maneuver, right? Now it's not common, right? But you want to frame it as broadly and as objectively as possible, right? Hidea.
Oh, sorry, I forgot to lower my hand last time.
No worries at all. Okay. All right, so make sense on framing disputes. How we doing here, guys? Feel good? Where am I? Okay. Okay, so now this is the meat of your answer. The arguments that you're going to identify, all right, and talk about, all right? So there are, for a lot of students, you're coming out of college, or your prior experience with exams is you're looking for the right answer. All right, this is particularly true of anybody who's an engineer or science or has a hard sciences background. They're looking for a right answer. You're not looking for the right answer in a law school exam. All right, you're looking for the best answer. All right, and professors traditionally will write fact patterns that are purposely ambiguous. Right, there's not a right or even sometimes a best answer, right? Both parties might have equally compelling arguments as to why a rule should or should not apply and dictate a particular situation. Okay, so rather than trying to figure out what the right answer is, try to figure out what the arguments are that both parties to a dispute will assert. Okay, and I promise you there are 3 types of arguments. All right, and they go in order of strength. All right, there are factual arguments. All right, the facts are such that that this party will either be found liable or won't be liable, and we'll talk about the breakdown of how these things differ. And the different subtypes of factual arguments and legal arguments and policy arguments in a second. All right, there are legal arguments. Okay, so these are not as strong as factual arguments, right? But they take a usually it's a standard or a test that is giving rise to some kind of presumption of a fact. Right. So one of the examples, if I'm assuming, is everybody taking torts right now? I'm assuming everybody's taking torts. If you have negligence, right? Negligence is duty, breach, causation, and harm, right? If you can establish that Diana and I have a dispute between one another, giving rise to a negligence cause of action, and negligence, and maybe she can prove that I had a special relationship with her. I'm her doctor, or I'm her lawyer, or somehow I'm a landlord that provides her with shelter. I have some kind of relationship where I owe her duty, right? And then for whatever reason she suffers some kind of harm because I breached that duty. Right, her argument would be that I breached it. Right, if there's no facts pointing to that, sometimes what you have to use is rely on a legal test. Right, so you might have heard of res ipsa loquitur. The thing sort of speaks for itself. Those are examples of legal arguments or standards or tests where Diana can say, "Look, I don't have any proof, direct proof, that Don breached his duty. However, I've got this harm that usually doesn't occur without a breach." And therefore, I'm going to show you that, and then the jury can presume that breach took place unless Don rebuts it, right? And then, so that's a legal kind of test, and we'll talk about that in a second. And then there's policy arguments, right? The reason why we have these rules is because we want people to behave in certain ways. Therefore, if you find in favor of Diana, it will dissuade people. It will chill people from doing this in the future, or it will encourage people to do something stupid in the future, right? Policy arguments cut both ways. All right. So let's just quickly talk about factual arguments. All right. Factual arguments are, the very first type of a factual argument is, remember we talked about, I said it before, the elements of every cause of action that you encounter are facts, right? Elements are facts. So to establish a cause of action, you have to establish that the facts exist, right? So sometimes, it'll be pretty clear from the hypothetical fact pattern that, okay, we've got a battery here, there's a claim for battery, or there's, these are facts that give rise to a claim for battery. There's intentional, harmful, or offensive bodily contact. All three are present in the hypothetical fact pattern. Therefore, it's going to be pretty easy for Diana to prove that Don is liable for battery. Okay. Sometimes facts are not so clear. All right. You could have different factual interpretations, right? It happens in contracts cases all the time, where you'll have, one term which means one thing, right? I think you guys probably have, you saw the one case that was talking about what is a chicken, right? But one party might mean one thing, one part, you might use the word chicken for one way, and somebody else might be using it in a completely different manner. All right. So how do parties use different facts, right? Or, a dozen versus a baker's dozen, 12 versus 13. Okay. Vague or ambiguous facts. This is another type of factual argument that one party may rely on. Listen, I know that I have to prove these elements. However, two of them are there. The third one, because of the way you wrote the exam, professor, it's sort of ambiguous as to whether it exists. Well, your professor wants you to identify that and wants you to get excited about the fact that you've identified that, right? And the very last type of factual argument is where there's just no proof of one of the elements, right? And that's another thing that I have to impress upon students is that when the call of the question says, let's assess Diana's rights and obligations and the various defenses that she may assert, right, under the fact pattern, recognize that the very best defense that you have as a party in a lawsuit is a missing fact, a missing element, right? Because it extinguishes the case outright, right? Or at least with respect to that cause of action. All right, does that make sense? Yeah. All right. A lot of times people will, jump to, oh, this is a murder case, but the defense is, self-defense, and they jump right to self-defense where maybe they didn't meet all the required elements of the statutory case for murder. Okay, so those are the different type of factual arguments that parties, that students have to identify in the hypothetical fact pattern, right? Differing interpretations of facts, as they're written, vague or ambiguous facts if they're present, and missing facts altogether. Okay. From a legal standpoint, all right, legal arguments, there's a bunch. All right. As I mentioned before, legal tests or standards. Those are used to support where an element otherwise might be missing. So if you have a missing fact, right, or a missing element, don't just give up, right? Don't just say, well, oh shit, I wish we had an element for breach here. I guess Diana can't recover against Don. No, that you've been going through your torts cases in class for the entire semester, putting all these little legal tests in your toolbox. So when you show up on the exam, it's time to pull them out and say, well, I mean, there's no direct evidence of a breach. However, we could use a legal test to establish breach. Let's use res ipsa loquitur, right? So you'll, other legal arguments are exceptions, right? So you'll have a general rule that you're given. This is generally how the case, that that this cause of action is determined, but there are exceptions to the general rule. Somebody have a question? No? All right. So where a prima facie case can be met, right? So if the plaintiff can say, or in the case of a criminal case, the government can establish the prima facie case for a cause of action, is there a legal argument that gives a defense or a justification, right? Don't forget that. That's another legal argument that parties will rely on. All right. A big one, and this is a really sophisticated exam taker, all right? But a big one is where a student can recognize that certain jurisdictions or certain the way a claim might be resolved is depending on where you are. Okay, so this is why I'm a big fan of reading the notes at the end of a chapter in your casebook, or not just learning the majority rules, but learning all the minority rules as well. So like, in the majority of jurisdictions, this case is handled this way, but in like Louisiana and Arizona, there's a bunch of crazy people over there, they handle it a different way. All right. If your professor doesn't tell you which jurisdiction you're sitting in when you're taking your exam, well, you just got another arrow in your quiver, right? So to say, well, professor, let me point out that if we're talking about the majority of jurisdictions, or if we're talking about a model penal code jurisdiction or in a UCC jurisdiction, this case might come out this way. Dolores, would you please come here? Here. She's like my neighborhood watchdog. This dog is, come here, look. Her name, Dolores, is perfect for her because she's like a little yenta. She's always in everybody's business. All right. But what you want to do is when you're identifying the reading the hypothetical is say, look, if I'm sitting in the majority of jurisdictions, or I'm sitting in one type of jurisdiction, this question will be resolved this way. All right. However, professor, I don't know if it's absent-mindedness, I wouldn't say this, or laziness, or what have you. You didn't tell me which jurisdiction I'm in, so I'm going to actually solve it both ways. That is a really great legal argument, showing a split in the law, how in various jurisdictions this will be answered. Because I promise you this, more than half of your class will not invoke minority rules, right? Will not try to solve the problem under the common law versus the model penal code. Now, don't go, if your professor says, hey, we're in a model penal code jurisdiction, don't say, well, by the way, it would be solved this way if it was under the common law. Don't go there, right? Because that's changing the question. But if it's open-ended and they don't tell you what kind of jurisdiction you're in, you want to identify both the splits in the law. And if it says, look, under either jurisdiction, it would be the same thing, let them know. Let your professor know, hey, professor, by the way, under the common law, it's the exact same analysis as the model penal code. Just wanted to let you know, all right? That's something that your classmates won't be doing, okay? And then the other thing is, where the facts exist, where you can advocate for the extension of a rule to make law, try it. Listen, professor, you taught us all these rules throughout the semester. I recognize that I'm not a plumber. I'm not just sitting here trying to fit pipes together, right? And to solve a problem. My job as a lawyer is to make new law. And, I can do that. I can take a rule that you've given us that could be extended to apply to this hypothetical fact pattern to solve a problem. So don't be afraid to throw that in. Now, it may not be your first argument, but it is a legal argument that you want to throw in there. Again, if for no other reason, to distinguish yourself from your classmates, because 95% of your classmates, 5% of the class just isn't going to do the work and master the law the way you have, right? So you're already better than 5% of the class, right? 95% of the classmates are walking in with the exact same law that you have, all right? how you're going to distinguish yourself is how you analyze those questions and apply that law in your exam, right? So making new law is a good way of doing that. All right. So I'm going to stop there for both legal, factual and legal arguments. Any questions? Nope. Okay. Last one is, this is sort of just what I was talking about in terms of intent, establishing a test for harmful or offensive. The last one I want to talk about is policy arguments. All right. Why a court would want to support, the application or prevent the application of a particular rule in a particular case. All right. So, this is like the weakest of the three types of arguments. Factual arguments are the best. Legal arguments sort of require you to sort of make a legal theoretical leap. Policy arguments are like, hey, we're not going to allow Diana to collect against Dr. Don, right? Because even though she got hurt and even though she broke her teeth and broke her ribs and, Don was probably negligent, if we allow Diana to collect in this case, then guess what? Medical costs rise across the board for everybody because Don's insurance goes up and, we already have a bad healthcare policy and we don't want to, like, it's a very weak argument, right? It's still an argument. All right. The fortunate thing is that your professors will, if they are policy driven, will tell you throughout the semester, hey, look, this is a common policy argument you'll see. There's only 3 or 4 in each of the classes, right? That you often have to focus on. It's really driven by your professor. But what you want to do is, recognizing that the application of legal rules oftentimes is to incentivize certain behavior, right? So by applying a rule to a hypothetical fact pattern, you may not agree with that rule, right? In this case, and you should sort of say why. All right, I think we have got somebody in the chat. Got a question? Oh, is this the bad criminal law professor at Brooklyn? I don't want to label her as bad. Oh no, this is Ari who said it. Yeah. All right. So so here's the deal, Ali. What you want to do though is if you have professors who are talking about policy all the time in class, fine. Understand what the policies are, right? That are driving that area of the law. But I can pretty much guarantee you, he or she is going to be testing you on the black letter law. All right. So just don't fall prey to what a lot of students will, they get to the exam and they've got all these policy arguments floating around in their head, but they haven't really mastered the black letter law. And they get to the exam and all of a sudden they're realizing like, holy Christ, this is just a problem. This is a issue spotter based on black letter law, which I haven't studied. All right. So don't fall into that trap. Okay.
Don, I think we had a question from Tony.
Oh, okay. Sorry. Didn't see that one. Oh yeah, Tony.
Yeah, so I wanted to ask, when making policy arguments, do you always have to use the policy theories that are given to you by your professor, or can you also make a policy argument using your intuition?
I mean, so I would, if your intuition is that you're, a brilliant legal mind, then maybe your intuition, right? I would have a basis for the policy argument, right? Like that, I wouldn't want you, sort of making up a policy argument on the way, as you're reading the hypothetical fact pattern. And sometimes policy arguments just don't exist, it's just so clear cut that, a policy argument wouldn't necessarily apply in that particular case. But, usually the policy arguments that you're making are ones that you've either heard in class or you've read from somewhere else. I mean, I just get a little nervous when somebody says, as a first-year law student, I'm going to make a policy argument based on my own intuition. That it could be ripe for disaster. Does that make sense, Tony?
Yes, it does.
Okay. Not saying that you're not smart enough to make, have a good intuition. I'm just like, I just get a little nervous, be like, oh yeah, sure. Yeah, use your intuition. Oh, that's all of a sudden then you're suing me for malpractice. All right. If I'm giving out that advice. All right. So any other questions regarding the identifying of arguments before we move on? Okay. So was it Hidayah? Had asked about how to structure. For some reason, these slides don't want to advance. Okay, I'll do it this way. Organizing your response. So rather than drafting a chart of here's the various parties to the dispute, here's the harm, and here's the harm causing act or omission. Where I would love to see you spend your time is in organizing your flip-flop trees. Okay, so let's see, hold on one second. Okay. So maybe this, you remember this from the summer. All right, this is a little handy device that I came up with when I was in law school, where for every dispute, so you have dispute number one, right? Whatever that frame dispute is, all right, you have an initiating party, the party who's going to bring the claim, right? And then you have an opposing party, the party who is going to oppose the claim. So the reason why I use those terms is because it's not always the plaintiff or the defendant, right? It could be in civ pro, it could be the movement, like somebody who's moving the court to do something, and the respondent, right? The person who's there, coming, trying to, prevent the court from taking certain action. All right. The movement could be the defendant in one case. So I always, try to identify who's going to initiate the claim, right? And who's going to oppose the claim, right? Use the law, initiate that cause of action or that legal rule, and then who's going to try to oppose it. And then for each of those parties, so the I here is the initiating party and the O here is the opposing party, they're going to have factual arguments, legal arguments, and policy arguments on both sides, right? So the initiating party is going to bring it, raise a legal claim, and ideally we'll have factual, legal, or policy arguments supporting that claim, and the opposing party will have factual arguments. This fact doesn't exist, it might be ambiguous. Legal arguments, there's no test or standard that establishes this, or policy arguments, we just don't want to have Diana collect in this case, on their own side. And then recognizing that the opposing party could have their own individual claims, right? So they're, in that case, they're asserting something. That's why we have it flop, right? You have the flip and you have your flop, right? The opposing party will raise arguments for or against the application of a particular rule, right? They will have their own legal arguments, and then they'll have their own policy arguments. And again, at that point, the flop here would be the initiating party would have, hey, look, under this, we have these factual arguments, these legal arguments, these policy arguments. It's almost like a game of ping pong. Where you see this most often is in, like, let's say in a contracts case, like one of the first questions that you're going to ask or answer in a contracts case is whether a valid contract was formed, right? You'll have the initiating party say, yes, a contract was formed and was breached, right? You might have the opposing party say, no, there was no contract. However, I did work and therefore I should be paid. So they might have a claim in quasi-contract. They're then initiating a claim for quasi-contract. I just want you guys to be recognizing that you have these parties bringing these actions, and by filling in these boxes, let's see. Oops. By filling in certain boxes, you're now outlining how you're going to organize your answer, right? So let's, for the dispute number one that we identified before, whether Cindy can recover against Dr. Green for medical malpractice when he performed the Heimlich maneuver, broke her ribs while performing the Heimlich maneuver. What is Cindy going to rely on? Cindy was a patient. Cindy, the hypothetical fact pattern said that, Dr. Green was overworked and had a lack of sleep, right? He broke her ribs. I don't know why it says teeth here, but broke her ribs, right? And then you have, how is she going to support her various, the actual breach? Well, there was a res ipsa claim there. She was unconscious. She didn't have knowledge of, how to perform a perfect time maneuver. She was a kid. And then, you'll have other facts that Dr. Green will use in support of, or against, I should say, the application of that rule. Was there a question? Oops. No. Okay. All right. And then what you'll do is for the next dispute, you'll do a similar flip-flop tree. Right. And this is really all you're doing is you're identifying factual, legal, and policy arguments that both parties are going to make in support of or against the application of a particular rule. This is it. This is the meat of your answer. This is what a great law student does. This is the hallmark of a good exam. Any questions? Yeah.
Yeah, I'm still confused on like what the flop part of it is. Is it the flop of this same dispute or is it a separate dispute?
It could be. We put it in there because you might have, counterclaims that come so. Imagine if the dispute was whether there was a valid contract between Cindy and Dr. Green, right? Cindy might have a claim for breach of contract, but he might, Dr. Green might be like, well, no, there was no valid contract, and here are the factual arguments as to why. But then I do have a different kind of claim arising out of that. Right. And it could be a separate dispute. It could be, is there a claim for quasi contract by Dr. Green? Sometimes you may not get to the flop might be a completely separate dispute, really depending on how the question is framed.
Okay.
All right. If I were to tell you where most of the hangout is going to be for you as a first-year law student, it's going to be in the flip top. Right. That's where you're going to be spending most of your time. Tony.
Yeah, so I've been using the flip-flop and I found it very helpful in my midterm. But contracts and taught, but like in the Civ Pro exam, I just don't know how this would apply. I feel like with Civ Pro, it's more about the rules, the rules of civil procedure, and that's it. So I just don't know how, in the context of Civ, for example, how this, how would you make factual arguments? How would you make legal arguments and policy arguments? I've really struggled around with that.
Yep. Again, so every one of those rules, the Federal Rules of Civil Procedure was written by the Supreme Court. It is a, very, very clearly written statute, right, that governs the litigation between parties in a federal district court. Every one of those rules contains elements, factual elements that need to be satisfied in order to, apply for a rule to apply. So that's where the initiating party might be a movant, right? If a defendant is moving to dismiss under 12b-6, right, there's going to be certain elements that they have to prove. Right. In that case, the defendant is the initiating party, and the elements will either be factual, legal, or policy arguments. I mean, it almost like, I feel like for Civ Pro, it actually fits the best. One of the things I will suggest to you, and I don't know if I remember if I mentioned it during the law preview class itself. But one of the things that I strongly suggest that you do before taking Civ Pro, the exam, is sit down and read all the rules, right? Sit down, don't read them in the Federal Register, like sit down and read from your Federal Rules of Civil Procedure supplement, read number 1 through 70, all right? Even if you're not covering discovery sections in the 20s or 30s, read them. because they do bear, they have bearing on, whether a motion for summary judgment can, be successful or not. But when you read them, Rule 1 through Rule 70, you get a really good understanding of how these rules interact with one another. And you'll also, really understand whether, under Rule 8 was process, how is the complaint properly drafted, whether the complaint was properly served or not, right? Those are factual questions, Tony, right? So all of those things an initiating party has to prove, right, in order to get the court to move a certain way. All right. Does that make sense?
Yes, it does. Yes, it does.
All right. And then, when it comes to policy, right, in a Civ Pro exam, you could always fall back to rule number 1. The entire rule, the entire federal rules of civil procedure were designed to allow for the effective, speedy, and efficient, use of the courts to resolve disputes, right? So, that is like your major policy question is like, is this efficient? Is this going to be efficient use of judicial resources, by granting or denying a certain motion? Then that's a great policy argument. You could always fall back to Rule 1. Make sense?
Yes, it makes a lot of sense.
All right. And then, obviously the various legal rules that you learn, right? I'll take it one more step, right? For subject matter jurisdiction, right? You have, are the parties diverse, right? Do they come from different states? Is there full diversity among all parties, right? On both sides of the V, right? Is the amount in question, or amount in dispute, does it satisfy the statute, right? Those are factual arguments. Make sense? Legal arguments would be, for personal jurisdiction, was there a nexus between one party and a particular state, right? That's making a legal argument to say that they were properly served under the jurisdiction, the long-arm jurisdiction of that state. Make sense?
Yes, it does.
Okay. I think that, again, I'm a big believer in, for Civ Pro, sitting down and reading those rules. A lot of students, most of your classmates will not do that. They are reading it. And if you're like most professors, who have this, sometimes they start out with Rule 11. They start talking about sanctions of like what could happen if you don't follow these rules, right? And then they jump to Rule 8, and then they go up to Rule 50. Like, read them 1 through 70. It'll take you about 3 hours to do it, right? But just read them in order. And all of a sudden it's like, wow, this makes pretty good sense. Like all this, if this is the way that a lawsuit starts, how a court handles it, and then usually where it ends, there's a definite timeline there. It makes a lot of sense. All right. Any other good question? We have another chat question. Yes. So Ali, so the flip-flop tree is done in the 25% of the time that you're writing, you're outlining your question prior to doing your writing, right? And my guess is the more you practice this, right, the easier it becomes. You cannot show up on your exam and not having practiced the flip-flop, okay? For me, it used to be, it wasn't this nice and neat. It was usually just a T, with parties on either side, and then I would just go FLP, right? And so you can sketch these out pretty quickly, but also you can see the whatchamacallit, you'll have your hypothetical fact pattern, which is being cut up or highlighted or circled or what have you, with all these various arguments, whether it's factual, legal, or policy. Okay, good question. Hold on. Oh, so Lucy says, I made policy arguments based on what we have actually do in practice, and criminal law professor hated it. Oh, okay. That's fine. Then, if she hated it, then don't give it to her. When Lucy, can you just pop on the mic?
Yeah, for sure.
Yeah, describe what happened.
She just, it was around felony merger law and how we do it in Georgia and some of the legislation that we have been working on this year, and why people don't like, don't like it that way. But she was a stickler for MPC.
All right. So she was looking more for a factual legal arguments and didn't want you touching the policy.
Yeah, for sure.
So then the good thing to know before you walk into the exam, right?
It would have been good.
All right. Okay. So let's see where we are here. I think we're pretty close to the end. Now for again, if we're trying to make your professor's job really easy, here's how I want you to organize your dispute. All right. For every dispute, I want you to have a DREC, all right, which is identify, the one sentence frame dispute. All right. State the rule or rules, all right, that the parties will use, that the initiating party will use to assert the cause of action or legal claim, right? If there's elements, obviously there will be, but if there's more than one element, enumerate them, 1, 2, 3, A, B, C, all right? For your arguments, have a separate paragraph for each factual, legal, or policy argument that you identified in your flip-flop tree, all right? And this is the bulk of your answer, right? So it's going to be a very simple dispute number 1. Here's the frame dispute. Rules. Here are the rule or rules that are going to govern this dispute. Arguments. Here are the arguments for the application of that rule, and here are the arguments against the application of that rule, and that's going to be the bulk of your answer. And then a 1-sentence or 2-sentence paragraph that predicts the outcome, right? Who should win this dispute, all right? And then put a period at the end of that conclusion and move on to the next dispute. Hidayah.
Yeah, so I'm wondering for,
right?
Yes, you did. I'm wondering for certain rules that are not like as cut, like if there are facts that have the dispute whether this rule is in play, should you have like a separate like argument to say that this rule is applicable? Does that make sense?
Sure. Yeah. But you would argue it as, hey, the party will say medical malpractice exists, right? You'll frame it in your dispute. And then, the first argument that you'd have from the opposing party is, this isn't medical malpractice, right? So that's a legal argument that you would have, that one of the parties. But are you saying that you'll need it like if you look at some of the hypothetical fact patterns that we gave you in the law preview text, right? The dispute might be very, very broad. Whether a contract exists between Don and Diana, right? A contract exists when you have offer, acceptance, and valid consideration, right? Don, sorry about that. Don will argue that an offer exists because A, B, and C. Diana will, so like then you're establishing, simply by the elements, whether that cause of action is even in play. Does that make sense?
Yeah, so I guess so you would organize your disputes by the elements per se?
So it really, no, it could, yeah. I think the rules section is going to dictate how you're developing your argument section, right? Your dispute section is really just like, what's the most logical way to attack this hypothetical fact pattern, right? Usually it's between parties. Dolores, come here. Oh, you're so bad. So it's usually going to be between parties that your disputes are organized, right? The rule is going, the arguments is usually going to be dictated by the rules that you and the elements of each of those rules that you're asking or you're identifying. Does that make sense? I know I didn't make that clear. So if I have to restate it, I will.
No, I'm following now.
Okay. Oh, it sounds like you have a dog too.
I do. I do have a little puppy.
I think she's responding to your dog. All right.
Yeah, I think the same thing is happening.
You are so bad. You are the worst. All right. Okay. So do we understand now that we're doing a dispute, a DRAC for every dispute that you identified, and you're just moving on? There's no, at the end of your exam, the essay part of your exam, you might have 9 different disputes. There's no overarching conclusion for every one of them. You're just going through and doing every one of the disputes, and you're doing a DRAC for each one of them. All right. All right. I think that we're at the end. Any questions regarding any of this stuff? Amanda.
My torts final is multiple choice.
Mm-hmm.
Do you have any specific advice for, I find my biggest problem is I can eliminate half of the answers, and
Yep.
then if I miss it, it's because I picked the one that was the red herring, like
Yep.
the trick answer, if you will. How do I recognize that and not do that?
Yeah. So I mean, therein lies the art of taking a multiple choice question. As I mentioned, I don't know if you were on the call when we started out. We're doing a 1-hour Q&A with myself and Mike Sims, who's the president of BARBRI Bar Review. And BARBRI has the distinction of being an excellent instructor, and Mike does as well, I should say, an excellent instructor of how to take multiple choice questions, right? Because multiple choice questions are a favorite of law school professors right now, because at a lot of schools they want to get you accustomed to taking MBE style questions. So my best advice for you is the same advice I gave to my son who's taking the SAT today, is you need to do as many questions as possible, right? And there are plenty of resources out there. I know that BARBRI has a book that you can get for free, I think from the 1L Mastery Pro that you guys have access to. But there's also like the FINS multi-state method. There's a whole bunch of other resources that you can use to find, crim law or tort law or contract law questions in multi-state form, and just work with them, right? But the other big piece is going to be your mastery of the rules, right? The general rules and the exceptions. Usually with the red herring is somebody falls for the general rule but doesn't apply the exception, right? And then the other big red herring is understanding the split in the law, right? Like depending on where the hypothetical, the call to question tells you what jurisdiction you're in or not, all right? But that is, I mean, obviously that's going to be a tough part of taking what is, what looks like a really good answer, and then understanding why it's not the best answer, right? So that's just a mastery of black letter rules, and then really just practicing them, right? Because there's only so many ways that they can ask these questions, right? And especially in a multiple choice format, I guarantee you will see something that looks, if you do enough practice questions, you'll see it's something that looks like the question that you're going to be given or fed up on your final exam, right? So it's doing the practice question and then reviewing the answer and understanding why this particular answer was the best answer. Make sense?
Yes, my professor likes to use old bar questions that he just makes about SpongeBob or Butthead and Beavis, stuff like that. And then also several, because we have quizzes every week. So he likes to take an exact case and just change the names.
Yep.
So I've been doing the torts Q&A. I consistently do well. I just want to do better.
Good. No, I mean, and you should, but again, by working through the hypos, and by working through multiple choice questions, you're gonna see them all, right? It's just a matter of working through them and then reading the answers as to why one answer was good, but wasn't the best, right? All right. Is it Jaria?
Thank you.
Jaria.
Sorry.
So I kind of have like a twofold question, and I'm sorry if you answered this already. I had to step away for a bit. How do you recommend using, like a lot of the professors at UT have old practice exams up?
Mhm.
How do I use those for practice without burning through them? Like, should I do like start practicing with just one and like work my way up to a full exam, or like how to go about that? And then how my exams, most of them are open note. And so how can I be efficient and not rely on my notes, but still utilize it to organize my answer?
Sure. So first off, let me answer your second question first. For your open book exams, right? I'm assuming these are classroom exams?
Yes.
Okay. You're going to study for these exams as if they are closed book exams, period. All right. You're not going to be, relying on, your outline, which is a nice security blanket to have, right? Don't get me wrong. And having something right there will give you a little bit of peace of mind, but you're not going to be looking through your exam and thumbing through your outline, trying to find out, which legal rule you're going to apply and what the elements are. You just don't have time to do that. Every minute that you spend looking up a rule and its elements in your outline, somebody else is writing. Okay. So, have it there as a backup, but definitely study as if this is a closed book exam. Okay. One other piece of advice that your classmates won't be following, right? Many of your classmates will be spending a lot of time flipping through their outline because they were told that you can bring anything in, as long as it's not an attorney who passed the bar, to help you answer these questions. It's a really bad use of your time to be flipping through your outline when you should be writing. Okay. With respect to the practice exams, I don't think you open those until the reading period. Okay. Up until that point, you should be working with the flashcards, right? Working with multiple choice questions, working with hypothetical fact patterns that you get from other sources, right? That are answering distinct questions of law that you're learning in that time. But those exams are the best resource you have, that are going to anticipate what your exam is going to look like. Obviously, they're not going to be the exact same exam, but it will be the best resource that you have, and you don't want to burn through those, right? So wait until the reading period after you've completed your outline, right? Now we're studying from my outline, and I'm going to take a 3-hour torts exam in a classroom, either with myself or with some other students, right? Actually do it under exam conditions, and then see how I do, right? And oftentimes you won't have a model answer, right? Sometimes your professor will be kind and show you like, oh, this was the A+ answer for my last year's exam on torts, right? In which case you compare your answer to that, right? Without looking at it. Sorry, I'm trying to keep this dog from barking at everything going by the window here. But for your the last thing I want you to do is burn through that and not actually treat it like a real law school exam. Simply just sitting down for 3 or 4 hours, right, and answering these questions is going to be great practice for you, right? Getting you in the mindset of what it's like to sit down and take an exam in 4 hours without having to get up, without allowing yourself to get up, right? So I don't want you using those until the reading period, if that's helpful.
No, it is. Thank you so much.
Yeah, you're welcome. All right. Amanda, do you have another question? Or is that just you left your hand up?
I left my hand up.
No worries. All right. Anything else, guys, before I let you go early? Nothing? You feeling ready? Yeah?
I feel like it's kind of one of those situations where I don't know if I'm ready or not until I get there.
Listen, I don't think I think that you're probably in the same boat with a lot of other people. But my goal is that you're gonna walk in with a certain level of comfort that your classmates won't have, and with a certain discipline. Because if you look at this approach to exam taking, this is more science than art, right? Like, you know, your professor will say like, oh, the way to write a law school exam is to IRAC or whatever matrix you want to use, right? But they really can't even enunciate it, and it feels very amorphous. But when you have 5 steps that you have to follow into when you're attacking every exam, you know, it sort of gives you that structure of, I know what I'm doing here, and I promise you, more than half of your classmates will not. Okay, so I wish you guys all the very best of luck. I hope that you know, oh, I'm sorry, was there a question?
I think appreciate.
I have one question. This is actually kind of so my question is, do you have any tips on, because I am a part-time student and I work full-time, I just find it very difficult to be able to do like a lot of practice in the E&E books and Q&A books. Do you have any like tips and like getting my reading done? Like, do you have any tips on that? Because I feel like I'm not doing enough practice. I'm almost basically, I'm treading water, like the whole time.
No problem. Yeah, so have you gotten the flashcard series?
I did. So I have the digital version. So I try to go through.
I was going to suggest that. Yeah, I was going to suggest that. Are you the one with the commute, the 4 hours commuting?
No.
Okay.
I don't commute that far. And
good.
No, and I listen to contracts. Oh, it's mostly for contracts that I'm worried about, because contracts is a beast. But I like listen to like lectures. I have like I don't know if you are familiar with the crunch time, but I have like the crunch time, and I like listen to those like while I'm in the car. So like I'm trying my best to do, but I feel like I'm not doing enough practice, if that makes sense.
I mean, listen, my guess is, you know, you're not, right? But nobody is, right? It's one of those things that like you always can feel like you could do more. Your goal is to get to the end of this process and not have any regrets, right? That I wish I could have done more, right? But if you're, I mean, listen, if you're listening to the audio series, if you're flipping through the digital version of the flashcards, if you're, you know, at some point, I know this is not helpful, right? This is not a helpful, you know, answer. You could always do more, right? You always feel like you could do more. But it's like, I could always do more crunches, right? To get my Zac Efron abs. I know I could, I just like don't have time to do it, right? Like, you know, if I were a Zac Efron, I guess I would have the time to do it because that's my livelihood, right? But like, if you're, first of all, I have the utmost respect for you as a part-time student. I don't know how part-time students do it. It's really tough. Diana, were you a part-time student by any chance? No,
I was full-time.
Yeah. You know, if it's a matter of finding time, you know, are you using like early morning, you know?
Well, I'm a teacher, so I go to work pretty early.
Yeah.
So, I mean, I try to use like my lunch break sometimes to like get in some practice. I just had to turn in grade. So like, I haven't had time really during the day to like get as much practice done. So like, I have fallen a little bit behind, but I'm just trying to like you said, like, I don't want to leave this process thinking that I could have done more. So I'm just trying to make sure, like, what can I do to prioritize, like, yeah, no, what can I do to like kind of prioritize my practice? Because after taking the midterm, that's what I realized I was lacking. I was lacking like more of that practice.
So the easy answer is more practice, right? The harder answer is how to do it, right? Because you can't do it at the expense of not reading the cases, right?
Right.
So, I mean, it's really tough for me to answer that question, other than, as long as you feel as though you can get to the end of the semester and get your grades back and be like, well, there was nothing more I could have done, then you're in a position to say, like, I've done everything I possibly can, right? I wonder, like, as a teacher, do you have now like a certain amount of empathy? What do you teach?
I teach first grade.
Oh, first grade.
Yeah.
So are you like, first of all, your grades are due? Like everyone's getting an A. All right, come on. All right. Like
Not in my class, no.
I just took a bunch of time off your, like, pass everybody. All right. Sharing, Diana, you get a D for sharing, but everybody else, all right. I was just wondering if, like, now you're like, oh God, if you were teaching like high school math or something like that, like, wow, I really feel bad for these kids. As long as
it's because of the nature of like teaching younger kids. Like when you teach older kids, you can kind of teach them a concept and like let them be, and then I can maybe study in the background. My kids are little, so and because of the pandemic, basically don't know what they should know, so it's taking more effort than I anticipated prior to deciding to continue to work and go to law school.
Right. God bless you. I mean, really, like, I mean, you're doing God's work with, especially a first grade teacher. Listen, I have 3 kids. I don't even want them, like honestly, like by the time they were going to school, I was like, they're your problem now, at least for 8 hours, really, I truly commend you. But like, again, if it's a matter of, I guess if it came down to a matter of briefing your cases versus doing more practice, I would rather you be doing more practice.
Okay.
If that could save you some time, right?
Okay.
I wouldn't want to see you do it, and I would want to see you do it all, but recognizing your situation, I don't know if that's possible,
Okay.
But practice is key on this one,
Right. Okay.
All right.
Thank you.
Oh wait, there's more in the chat. Hold on. By the way, I love my first grade teacher. Hang in there. All right.
I think we had a question about what the specific flashcards are, Don.
Oh, sure. Yeah. So the flashcards that I love are Emmanuel's Law in a Flash. All right. And they're published by Wolters Kluwer. And then I know that the digital version of those are available they were licensed to a company called Space Repetition. All right. So if you just do a Google search for Emmanuel Law in a Flash, those things are phenomenal, right? And it's less, it shows you what the black letter law is for the various subjects and the various rules within those subjects. But what I love about them is behind every black letter rule, there's 10 or 15 hypotheticals where the rule survives or it fails. All right. And again, there's only so many ways these professors can structure these questions. Therefore, you pretty much have seen it all. So if you haven't picked those up, I strongly suggest that you do. And I want, ideally you would have been working with these things since August as a go forward, part of that cumulative review that we talk about during the law preview class. All right. All right. Any more questions?
Any other study aids that you recommend?
From getting back to Capricious, anything that's a practice aid. I don't necessarily love the commercial outlines of commercial outlines, right? Sure, pick one and like if it's going to help clarify a particular area of the law, that's great. But towards this point in the semester, I found that what students most need, in addition to clarification, is practicing, because practicing will then provide the clarification that you're looking for, especially if it's distinguished between the best and the in a good answer on a multiple choice question, identifying, practicing with hypothetical fact patterns is the best way to do it. All right.
I've had really good luck with the examples and explanations books. My Civ Pro teacher actually forces us to read them. They're part of our assigned reading.
Yep.
And they're spectacular. I bought them for property and torts as well, and they're immensely useful. It is all practice questions with some explanation before that. It's really super useful. I would highly recommend them.
Yep. Especially for Civ Pro. I mean, if anybody's, Tony, you mentioned before that you're struggling a little with Civ Pro. The Civ Pro book by Joe Glannon on it, the explanations and examples book is basically the Bible of Civ Pro. I mean, like he does a great job at breaking down some of the hard questions in Civ Pro and then analyzing them for you. So this dog is just a menace. I apologize. All right. Guys, I don't want to take up any more of your time. You got a full day of studying, I'm sure, to now move on to, but I hope this was helpful. To the extent that you have any other questions, you guys know how to reach me. You can reach out to me directly. My email address, mac@lawpreview.com, comes right to me. So if you have any questions, please do not. And I have to go walk this dog. All right, bye guys.
Thanks, John. Thanks, everyone.
Yeah, you're very welcome.